Page 204, Lord Justice Atkin, quote, "The question now arises whether the persons interested are entitled to the remedy which they now claim in order to put a stop to the unauthorised proceedings of the Commissioners. The matter comes before us upon rules for writs of prohibition and certiorari which have been discharged by the Divisional Court. Both writs are of great antiquity, forming part of the process by which the King's Courts restrained courts of inferior jurisdiction from exceeding their powers. Prohibition restrains the tribunal from proceeding further in excessive jurisdiction. Certiorari requires the record or the order of the court to be sent up to the King's Bench Division to have its legality inquired into, and, if necessary, to have the order quashed. It is to be noted that both writs deal with questions of excessive jurisdiction, and doubtless in their origin dealt almost exclusively with the jurisdiction of what is described in ordinary parlance as a court of justice, but the operation of the writs has extended to control the proceedings of bodies which do not claim to be and would not be recognised as courts of justice. Wherever any body of persons having legal authority to determine questions affecting the rights of subjects and having the duty to act judicially act in excess of their legal authority, they are subject to the controlling jurisdiction of the King's Bench Division, page 206, exercised in these writs. I can see no difference in principle between certiorari and prohibition, except that the latter may be invoked at an earlier stage. If the proceedings establish that the body complained of is exceeding its jurisdiction by entertaining matters which would result in its final decision being subject to being brought up and quashed on certiorari, I think that prohibition will lie to restrain it from so exceeding its jurisdiction. Page 207. It is necessary, however, to deal with what I think was the main objection of the Attorney General. In this case, he said the Commissioners come to no decision at all. They recommend an order embodying a scheme to the Minister of Transport, who may confirm it with or without modifications. Similarly, the Minister of Transport comes to no decision. He submits the order to the Houses of Parliament, who may approve it with or without modifications. The Houses of Parliament may put anything into the order they please, whether consistent with the Act of 1919 or not. Until they have approved, nothing is decided, and in truth the whole procedure, draft scheme, inquiry, order, confirmation, approval, is only part of a process by which Parliament is expressing its will, and at no stage is subject to any control by the courts. It is unnecessary to emphasise the constitutional importance of this contention. Given its full effect, it means that the checks and safeguards which have been imposed by Act of Parliament, including the freedom from compulsory, page 28, taking, can be removed, and new and onerous and inconsistent obligations imposed without an Act of Parliament and by simple resolution of both Houses of Parliament. I do not find it necessary to determine whether, on the proper construction of the statute, resolutions of the two Houses of Parliament could have the effect claimed. In the provision that the final decision of the Commissioners is not to be operative until it has been approved by the two Houses of Parliament, I find nothing inconsistent with the view that in arriving at that decision, the Commissioners themselves are to act judicially and within the limits prescribed by Act of Parliament, and that the courts have power to keep them within those limits. It is to be noted that it is the order of the Commissioners that eventually takes effect. Neither the Minister of Transport who confirms, nor the Houses of Parliament who approve, can under the statute make an order which, in respect of the matters in question, has any operation." End quote. Lord Justice Younger, page 212. That Act, the Act of 1919, in my judgment, contemplates that the Commissioners' order, which, when approved by a resolution passed by each House of Parliament, is to have effect as if enacted in the Act, embodies only a scheme which, under the Act, the Commissioners are given power either to approve or formulate. Every scheme under the Act remains the scheme of the Commissioners even after it is confirmed by the Minister of Transport and approved by Parliament. The modifications in a scheme inserted either by the Minister of Transport or by Parliament are limited to modifications, as I read the Act, which might have been lawfully made under the powers of the Act by the Commissioners themselves had they been so minded. Parliament has not by the Act conferred upon the Minister of Transport, nor has it in terms reserved to itself by a mere resolution of both Houses, power, under the name of modifications in a scheme of the Commissioners, to insert in a scheme provisions which would under the Act be beyond the powers of the Commissioners if inserted by them in the scheme in the first instance. So, at any rate, I read the Act. Fortunately, however, it is not necessary in this case to decide the very serious question whether, if at any time Parliament should approve by resolution of each House a scheme, page 213, which, adopting, if I may, the language of Lord Robertson in Russell and Magistrates of Hamilton, 25R 350-357, could in fact be shown to be an abuse of the statute, the scheme so approved would nevertheless, by virtue of Section 7, subsection 2, have effect as if enacted in this Act, and would have to be given statutory force by every court in which its terms were canvassed. To suggest that such a question is one which may, in view of the terms of this subsection, arise, is not of course to suggest that Parliament cannot sanction and give the effect of statute law to any scheme it likes. It is only to suggest that it may not have in this Act reserved to itself the power by a mere resolution of each House to give statutory effect to a scheme the formulation of which it has not by the statute authorised. No such serious question, however, arises for decision now. For the moment it is, I think, enough to say that, whatever may be the effect of a joint resolution when once it is passed, Parliament in this statute contemplates that no such resolution will approve, except possibly by inadvertence, a scheme which it would under the Act be beyond the powers of the Commissioners to formulate or of the Minister of Transport to confirm. If that be the true view of the statute, the interference of the court in such a case as this, and at this stage, so far from being even in the most diluted sense of the words a challenge to its supremacy, will be of an assistance to Parliament. It will relieve each House, to some extent at least, from the risk of having presented to it for approval by resolution schemes which go beyond the powers committed by the statute to the Commissioners who made them or the Minister of Transport who confirmed them. It will leave each House to a great extent untrammelled by any apprehensions of this kind to devote itself to the consideration of the question the Act has undoubtedly reserved to it, namely, whether in the particular case the scheme should be approved or not. For these reasons, I'm of opinion that if we have the power in this case to interfere, we are rendering a service not only to the parties concerned, but to each House of Parliament itself by exercising that power as we propose to do. End quote. Board of Education and Rice, L.R. 1911, Appeal Cases 179. Section 7, subsection 3 of the Education Act 1902, to Edward VII, c. 42, provides that, if any question arises under this section between the local education authority and the managers of a school not provided by the authority, that question shall be determined by the Board of Education. The Board was required under this subsection to determine 1. Whether the local education authority, having fixing and paying the salaries of the teachers, fulfilled their duty under subsection 1 of section 7 of the Act. 2. Whether the salaries inserted in the teachers' present agreements are reasonable in amount and ought to be paid by the authority, or what salaries the authority ought to pay. The Board having purported to decide these questions by a document which did not dispose of them, it was held that the purported decision must be brought up by writ of certiorari and quashed, and that a writ of mandamus must issue commanding the Board to determine the questions. Page 180, the Lord Chancellor, Lord Lawburn. Quote, "It is unnecessary to enter into detail upon the protracted dispute between the Swansea Local Education Authority and the managers of the Oxford Street voluntary schools, technically termed non-provided schools. Certain salaries were paid to teachers by the Local Education Authority in the provided schools within their area. Smaller salaries had been paid to the teachers in the voluntary schools prior to the Act of 1902, and after that Act passed, the same system of paying smaller salaries was continued. Then some of the teachers gave notice upon the ground that their salaries were inadequate and below those paid to their comrades in the provided schools, and the managers of the Oxford Street schools pressed upon the Local Education Authority the fact that they were able to keep their teachers only by finding out of their own pockets, or by the assistance of well-wishers, the difference between the two scales of salary. They claimed that by refusing to level up those salaries to the same scale, the Local Education Authority had failed to discharge its statutory duty of maintaining and keeping efficient the Oxford Street schools. Mr. Hamilton, K.C., who was sent down to inquire and report to the Board of Education in London, page 181, reported that there had been such a failure. And upon all the evidence before the House, there can be no manner of doubt that he was right. I proceed now to consider what is the statutory duty laid upon the Board of Education in regard to disputes of this kind. Their duties, so far as concerns the present litigation, are twofold. In the first place, they are required by Section 7, subsection 3 of the Act of 1902 to determine a certain class of questions. The words of the subsection run as follows. If any question arises under this section between the Local Education Authority and the managers of a school not provided by the authority, that question shall be determined by the Board of Education. The Attorney-General argued, as I understood him, that the questions then pointed at are only such as arise from the statutory relations between the Local Education Authority and managers, and are not such as arise from the duty of one or other towards the public. He contended that the duty of maintaining and keeping efficient a non-provided school, though it is in terms imposed by Section 7 of the Act, is not a matter which can be a question between the Local Education Authority and the managers, so as to come within the jurisdiction of the Board. I cannot accept this view. The managers are directly interested in the proper maintenance, and I do not understand how it can be held that if they do so call upon the Local Education Authority, and the latter disputes the point, it is not a question arising between them. Equally, I fail to understand how it can be held that such a question is not one arising under Section 7, page 182, for it is only under Section 7 that the duty is created, and all questions arising under Section 7 are to be determined by the Board of Education by virtue of the third subsection. Comparatively recent statutes have extended, if they have not originated, the practice of imposing upon departments or officers of state the duty of deciding or determining questions of various kinds. In the present instance, as in many others, what comes for determination is sometimes a matter to be settled by discretion involving no law. It will, I suppose, usually be of an administrative kind, but sometimes it will involve matter of law as well as matter of fact, or even depend upon matter of law alone. In such cases, the Board of Education will have to ascertain the law and also to ascertain the facts. I need not add that in doing either, they must act in good faith and fairly listen to both sides, for that is a duty lying upon everyone who decides anything. But I do not think they are bound to treat such a question as though it were a trial. They have no power to administer an oath and need not examine witnesses. They can obtain information in any way they think best, always giving a fair opportunity to those who are parties in the controversy for correcting or contradicting any relevant statement prejudicial to their view. Provided this is done, there is no appeal from the determination of the Board under Section 7, subsection 3 of this Act. The Board have, of course, no jurisdiction to decide abstract questions of law, but only to determine actual concrete differences that may arise, and as they arise, between the managers and the local education authority. The Board is in the nature of the arbitral tribunal, and the Court of Law has no jurisdiction to hear appeals from the determination either upon law or upon fact. But if the Court is satisfied either that the Board have not acted judicially in the way I have described, or have not determined the question which they are required by the Act to determine, then there is a remedy by mandamus and certiorari. In the second place, the Board are authorised by Section 16 of the Act 1902 to make such order as they think necessary or proper for the purpose of compelling the local, page 183, education authority to fulfil its duty, if after holding a public inquiry they think it has failed to fulfil any of its duties under the Act of 1902. This is a perfectly distinct thing from what is prescribed by Section 7, subsection 3. It is designed to enable the Board of Education, if they think it right, to make an order and to enforce by application to the courts of law obedience to such order as they may make. It does not deal with the determination of disputes between a local educational authority and managers, though, if such dispute is decided one way and the local educational authority refused to act in accordance with the decision, its refusal may be followed by an order under Section 16 and by an application to the court to enforce it. In the coil in which this quarrel, simple as it is in itself, has been entangled, this distinction may have been somewhat overlooked. Page 184. Such being the duties of the Board of Education, I next inquire what it is that they have done. They have purported to determine a question under Section 7, subsection 3 of the Act, which I do not think was really that which arose between the parties. Page 185. I think there has been confusion between the points that were to be decided and the arguments of either side, and perhaps also a confusion between the Board's duty under Section 7, subsection 3 and their duty under Section 16. The managers were entitled to an explicit determination of the questions which they raised. This they have not obtained. That suffices to dispose of the case, and I move your lordships to dismiss this appeal with costs. End quote. Earl of Halsbury. Quote, My lords, I am of opinion that this judgment ought to be affirmed. The duty of the education authority was to keep the schools efficient. This duty they neglected and did not keep the schools efficient. The local, page 186, education authority assumed to itself an absolute autocratic authority as to what schools they would keep efficient, and I cannot doubt for myself that they thought they were entitled to starve the church schools and give advantages to the provided schools which they would not grant to the church schools. End quote. Page 187, Lord Atkinson. Quote, My lords, I concur in both the judgments which have been delivered. End quote. Lord Shaw of Dunfermline. Quote, My lords, I concur in the judgment of the Lord Chancellor, and I desire to add two statements in the light of which this concurrence will, I trust, be read. With regard to the local education authority, that authority is not before us, and we have not had the advantage of hearing their views presented at your lordship's bar. Speaking, therefore, for myself, I am not satisfied that any observation reflecting upon their conduct would be justified from me. On the point of discrimination, my lords, I desire to say this, that where the circumstances are the same, discrimination primarily requires justification, but on the other hand, this state of circumstances, that is to say, a state of complete similarity in the varying conditions as to schools, staffs, localities and otherwise, may be most infrequent, and to apply the same standard to dissimilar circumstances is, in my humble judgment, itself such a discrimination as would also require justification. The point really underlying these two questions, which are now remitted to be answered, is whether in the individual case, and apart altogether from reference to other cases, or to a general standard, efficient education has or has not been provided in the particular school. To that, as the ultimate issue, the attention of the parties must be directed. I do not doubt that the local education authority must act impartially, but upon the whole I desire to interpose these observations to my assent to the judgment proposed from the Woolsack. End quote. Lord Mersey. Quote, My lords, I entirely concur. End quote. End of chapter 9.